known as Republic Act number 7394. And I, in particular, am tasked with providing with you a discussion on an overview of this law, the Consumer Act of the Philippines. So my discussion will basically revolve around basic principles that are embodied in this law, the Consumer Act of the Philippines, or Republic Act number 7394. But before I formally start with my discussion, let me ask each and every one of you, by a show of hands, who among you has done some online shopping during this COVID-19 pandemic? Huwag na tayong mahiya. Okay. So a lot, okay. Okay, so well, I honestly have done some online shopping during this COVID-19 pandemic as well. And so it is interesting to note that in a study on the frequency of online purchases that were done by Filipino consumers during the COVID-19 pandemic, which a study was conducted on May of 2020, and the results were released on June 2020, with respondents amounting to more than 10,000 respondents. It was indicated that those Filipino consumers who had done some online shopping transactions for several times a month are of a more or less equal number with those Filipino consumers that have done online shopping transactions for less than or none at all during this COVID-19 pandemic. And also there are those Filipino consumers who have done online shopping once or twice a week per month. There are those who have done online shopping 3 to 6 times a week per month, as well as those who even have done online shopping for every day per month during this COVID-19 pandemic. However, regardless of where you see yourself from these 5 groups, I am pretty sure that you all, most if not all, are very interested or are very known with this issue. This issue circulated around Facebook and is scattered and spread like wildfire on that social media website on October 21 of 2020. This was headlined, "Imbes na cellphone, dalawang pirasong kahoy ang natanggap ng isang online shopper." Basically, what happened in this incident was that there was a Filipino consumer in the name of Mrs. Ha who purchased 2 mobile phones from Lazada, particularly from Laz Mall, amounting to a total of 4,000 pesos. However, to her shock and dismay, when her parcel arrived, what she received were not 2 mobile devices, but what she received were 2 blocks of wood instead. And so what am I trying to point out? What am I trying to get to with this discussion? What I'm trying to get to is that this kind of incident that has happened to Mrs. Ha can also happen to each and one of us. And so if this same incident happened to one of us, do we know our rights? And should we know our rights, do we know how we can invoke these rights? Or from whom we can invoke these rights? And so I'm saying this because I do think that we can have a better grasp and study of the provisions of this law, the Consumer Act of the Philippines, by not just having a thinking that we have to know the provisions of the law for purposes of exam or eventually the CPA licensure exam. But we have to appreciate the fact that the transactions that are covered by this law, the Consumer Act of the Philippines, are transactions that actually happen in our day-to-day lives. These are transactions that can happen to every one of us. And so with this realization, I do think that we can have a better grasp of the provisions of this law, the Consumer Act of the Philippines. So after having said that, what is or who benefits from this law, the Consumer Act of the Philippines? Well, basically, those who will benefit from this law are consumers. And the Consumer Act provides that a consumer is a natural person who is either first a purchaser, second a lessee, third a recipient, or take note of this, fourth, a prospective purchaser of what? Consumer products, services, and take note of the third one, or credit. And so, in short, who benefits from this law? All of us. Because all of us are purchasers. All of us are consumers. All of us can benefit from this law. Accordingly, whenever there are doubts as regards the implementation as well as the interpretation of the provisions of this law, the Consumer Act of the Philippines, these doubts should be resolved in accordance and in favor of the best interest of the consumer. However, this will only apply if there are doubts as to the provisions of Consumer Act of the Philippines. Because if the provision is clear and comprehensible in itself, then there is no room for interpretation. Our only option, apply the law. But if there are doubts, then these doubts should be resolved in favor of the best interest of the consumer. Now, after that, what is the purpose of this law, the Consumer Act of the Philippines? We have general purposes. And I think that it is quite easy for us to be able to remember these general purposes because the mnemonic is something that is very relevant in our present times. It is PPE. First, to protect the interests of the consumer. Second is to promote the general welfare of the consumer. And third, to establish standards of conduct for business as well as industry. Why do we have to study about the general purposes of this law? Because, guys, we have to remember that when push comes to shove, and we cannot anymore remember the specific provisions of this law, the Consumer Act of the Philippines, then it is but important for us to just go back to the general purposes. Because more often than not, the specific provisions of the Consumer Act of the Philippines find their foundation, find their basis on these three general purposes. And from these three general purposes, we go to a wider viewpoint to go to the specific purposes of this law. But for purposes of this discussion, I would like for us to narrow down our attention to the fourth specific purpose, to provide adequate rights and means of redress. Well, the Consumer Act of the Philippines does not expressly enumerate what our rights as consumers are, but the provisions of the Consumer Act of the Philippines do embody what our rights as consumers are. And so what are our consumer rights? We have 8 basic consumer rights. And for purposes of having a simpler and easier understanding or memorization of these consumer rights, we have a mnemonic, basic, rep, reg. And it is also very useful that the first word basic is also related to the first basic consumer right, which is the right to basic needs. This right to basic needs is related to our right to life. And the right to life is an inherent human right. Second is the right to safety, because remember, one of the general purposes of this law is to protect the interests of the consumer. Third, the right to information, because the Consumer Act of the Philippines provides several provisions as regards labeling, packaging, deceptive sales, as well as advertising, all of which will be discussed later. Fourth is the right to choice. The Consumer Act of the Philippines provides for several quality and safety standards. And so with these standards, us consumers can have more confidence and comfortability, or comfort rather, when choosing from an array or a variety of products, because we are sure that whatever we choose from these products, it is of good quality in accordance with the provisions of the Consumer Act of the Philippines. The fifth consumer right is the right to representation, because with this law, the Consumer Act, our market is no longer just influenced by sellers. It can now be influenced by us, the consumers, taking into consideration what our rights and what our rights are. For example, with respect to supply, for demand, for competitive prices, the benefit, our best interest as consumers will also be used as inputs as regards the market. Sixth is the right to redress, because it is not only enough that we know our basic consumer rights. Because even if we know our consumer rights, but we do not know how we can invoke them, or there are no means by how we can invoke these rights, then these rights will be useless. Next, the right to consumer education, basically because the Consumer Act of the Philippines provides for certain means on how we as consumers can possess the necessary capability to be informed consumers. And finally, the right to a healthy environment. This is in connection with our Constitution, because the Constitution provides that all of us have a right to a balanced and healthful ecology in accord with the rhythm and harmony of nature. O, diba? The Consumer Act of the Philippines even finds connection with our supreme law of the land, which is our Constitution. Now, let's go with the first chapter of this Consumer Act, Consumer Product Quality and Safety. Under this, our state has the duty to, among others, provide safety and quality standards and to protect against unreasonable risks of injury. This is, okay, it is because of this duty of the state to provide safety and quality standards as well as to protect against unreasonable risks of injury that the state has a prohibition against defects or defective products. Any manufacturer, producer, or importer, whether Filipino or foreign, shall be liable for damages that are caused to Filipino consumers due to the defects in their own products. And so this would lead us to thinking, when is there a defective product? When is a product considered as defective? A product is considered defective when it does not offer the safety that is rightfully expected of it. So how can we determine whether or not a product does offer the safety that is rightfully expected of it? Well, the Consumer Act states that there are several factors that we can use. And so among these factors, it enumerated three: the presentation of the product, the use and the hazards reasonably expected of it, and finally, the time that the product is put into circulation. Remember that this list is not exclusive. However, even if this list is not exclusive, the Consumer Act provides that the fact that a product of a better quality than a prior existing product does not automatically make this prior existing product as defective. Okay, so now as consumers, we have a claim. A product is defective. What are the defenses that can be raised by the manufacturer, the producer, or the importer? The manufacturer, the producer, or the importer can raise the following defenses for them not to be held liable. First, I did not place the product on the market. Or I did place the product on the market, but the product was not defective. Or finally, you as the consumer or a third party is the one who is solely at fault. Okay, so at this point, the consumer has a claim. The product is defective. However, the manufacturer, the producer, or importer has a defense. To whom should these claims be invoked? And to whom shall these defenses be raised? These claims and defenses can be raised to the implementing agencies. And we have a mnemonic, HATI. So who are these implementing agencies? First, the Department of Health. The Department of Health with respect to food, drugs, cosmetics, devices, and substances. Next, we have the Department of Agriculture as regards products that are related to agriculture. And finally, the Department of Trade and Industry, which has a catch-all provision with respect to other consumer products that are not specified above. It is, okay, as implementing agencies, the Department of Health, the Department of Agriculture, and the Department of Trade and Industry, in their sound discretion, can declare a product as injurious, unsafe, or dangerous, and as a result, it has the power to order the recall, the ban, or the seizure from public sale or distribution of these consumer products. Now, having talked about defective products, let us go now to imported products. Remember that as a general rule, imported products can be admitted here in the Philippine territory. As an exception, these imported products cannot be admitted here in the Philippine territory if first, fails to comply with an applicable consumer product quality and safety standard. Because remember, the state has the duty to provide for this consumer and quality standards. And so there is an obligation to indeed comply with the said applicable consumer product quality and safety standards. Second, if it is determined to be injurious, unsafe, or dangerous. Third, if the imported product is substandard. And finally, if the imported product has the material defects. Again, when is a product considered defective? If it does not offer the safety that is rightfully expected of it. Now let's go to chapter 2, which talks about food, drugs, cosmetics, and devices. Okay, and I would like for us to focus on poisonous ingredients. Now, as a general rule, of course, any poisonous or deleterious substance which is added to a food product shall be considered as unsafe. But as an exception, these poisonous or deleterious substances can be considered safe provided first, it is required. Second, the poisonous ingredient cannot be avoided in the production of the food product. Or finally, the poisonous ingredient cannot be avoided by good manufacturing practice as regards the food product. However, these exceptions admit of a qualification. The Department of Health should be able to provide limitations on the quantity of poisonous ingredients that can be added to food products. And should the quantity added to should the quantity of poisonous ingredient that is added to a food product would exceed the limitations provided by the Department of Health, even though the poisonous ingredient falls under the exceptions, it will still be considered as unsafe. Now, at this point, I just want to say that the study of law is interdisciplinary. The provisions of our laws are connected with one another. And so when we study our laws, we can find certain similarities as regards the provisions. And because of this, with this realization, I would like to point out that even before the enactment of the Consumer Act of the Philippines, scattered provisions of our laws already provide protection to our consumers. Examples would be the law on sales, as well as the new civil code provisions as regards to torts. Remember, guys, we are already experts with this. What are the sources of obligations? Obligations are sourced from law, contract, quasi-contract, delict, and quasi-delict. Quasi-delict is otherwise known as torts. And so under the new civil code provision, there is a strict liability in that manufacturers and processors of foodstuff, drinks, toilet articles, and similar goods shall be held liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. Again, no contractual relation exists between them and the consumers. Because should there be a contractual relation between them and the consumers, then the obligation will not arise from quasi-delicts anymore, but it will arise from contracts. So in order for me to wrap up my discussion, I have two multiple choice questions. The first one is this. Who among the following is not covered by the Consumer Act of the Philippines? First, X, who availed of the tutorial services of ABC Learning Services to help his daughter cope with the modules sent in by her teachers for this school year. Second, Nakinig Ako Corporation, who purchased face masks from Shopee. Third, Y, who is a prospective buyer of a parcel of land located in an area currently being developed into a subdivision. Or finally, our favorite, none of the above. So I will be giving you 10 seconds to choose your answer, and your 10 seconds starts now. Okay, do you have your answers? And so our answer is, or the correct answer is actually letter B, Nakinig Ako Corporation. Do remember that the Consumer Act of the Philippines provides that a consumer is a natural person and a corporation is an artificial or a juridical person. As an artificial person, it is not considered as a consumer, and therefore he is not covered by the Consumer Act of the Philippines. Okay? So second question, which of the following transactions is not covered by the Consumer Act of the Philippines? First, M's transaction, with M buying 50 pieces of face shields from Lazada and paying the transaction through the mode cash on delivery. Second, N's transaction, who availed of home disinfecting services from COVID Go Away Corporation and paid using his credit card. Third, O's transaction, which is the leasing of a parcel of agricultural land owned by Z. Or finally, none of the above. Another 10 seconds, and these start now. Okay, so your 10 seconds is up. And the correct answer is our favorite, none of the above. Why? Because again, a consumer is a natural person who is either a purchaser, a lessee, a recipient, or a prospective purchaser. And what can be the objects of the transaction? Consumer products, services, or credit. Remember that the third transaction was with respect to a lease. And a lessee is considered as a consumer under the Consumer Act of the Philippines. And the Consumer Act of the Philippines does not actually make a qualification with respect to the manner by which the transaction is to be paid. So the manner of payment, such as whether it is cash on delivery, payment of cash outright, or through credit transactions, will actually be insignificant in determining whether or not a transaction is covered by the Consumer Act of the Philippines. So with that, I have wrapped up my discussion on the overview of the Consumer Act of the Philippines. I do hope that I was able to impart with you useful information about this law, and I hope that I was able to hold my part of the bargain well. Okay? So Nico, I will stop now with my screen sharing. Thank you, everyone, and enjoy the rest of this discussion.
Yon, thank you so much, Vic, for that very wonderful presentation. I hope our accountancy students and graduates have learned a lot. So without further ado, let's call on our second speaker. Cha, nakamute ka.
Yeah, sorry, oo. Hello ulit, guys. I am Cha and another LSP. So let me first share my screen. Yan, okay. Let's start. So, sorry. I was tasked to discuss with you labeling and fair packaging, also under the Consumer Act of the Philippines. I know that you will be able to relate to this topic because labeling, alam nyo yan, kailangan may label. Alam nyo yan, nakikita nyo lagi yan sa social media. Okay, first, let's go to the Declaration of Policy or the rationale behind the law. The Declaration of Policy is actually summarize this way. So the purpose. So we can say that the purposes of this law is first to enable the consumer to obtain accurate information as to the nature, quality, and quantity of the contents of consumer products. And second, to facilitate comparison of the value of such products. So labeling is important in order for you as consumers to be able to know what that product contains. For example, you are in the grocery and then you are looking for a specific product. The labels will help you to compare the contents of the product, and in order for you to be able to buy what product you want to buy. So let's go to the main implementing agencies. First, of course, the Department of Trade and Industry, as expounded earlier. And then an additional agency is the Food and Drug Administration of the Philippines, which oversees the implementation of these rules with respect to food products and drugs or the medicines that we buy. Next, coverage. Of course, we should know which products are covered. Basically, all consumer products are covered. All consumer products which are sold in the Philippines, whether locally manufactured or imported. So it was discussed earlier that even imported products are covered by the Consumer Act, especially if they are to be used here in the Philippines. Next, let us discuss what is labeling. So basically, under the definition in the law, just to summarize, labeling is that which is placed in the product which distinguishes it or which identifies such product and contains the contents, the name of the manufacturer, etc. So I have here a tip for you. Always check the label. Yan. Alam niyo yan sa Nido, laging ano yan, pinagkakatuwaan yan sa social media, sinasabi. Always check the label. Okay. Yan. So, the manner of placing labels. How should the labels be placed? First, this manner of placing labels is for the benefit of the consumers. So, dapat it's conspicuous and easily understandable. So, it should be placed in a way that the consumer can easily read it. The next one is that the label should not be easily detached. So, hindi lang basta dinikit doon or natatanggal, something like that. So, dapat more or less permanent yung label. Parang yung gusto nyo, dapat permanent yung label. Ganyan. And then, there is a mandatory translation from English or Filipino language in the label, especially if the product is imported abroad. So, an example of the translation is this one. This product is Garnier, which is imported from Indonesia. We have here the English translation, and this is the original text, which is Indonesian. Yeah, so we have translation. Important yan if the product is imported. Okay, let's now go to the minimum labeling requirements for consumer products. First, of course, the trade name or brand name, the trademark, the business name, the address of the manufacturer, importer, or repacker in the Philippines. The next one is the general make or active ingredients, net quality of contents, country of manufacture, and the principal if it is being distributed by an agent. This enumeration are actually in the law. You can easily browse the law and then list them so that you can memorize them properly. And this additional minimum labeling requirements is included in an addendum to the implementing rules and regulations. It is now mandated that the country of manufacture be included, whether or not it is manufactured abroad or here in the Philippines. And of course, the expiry date, the warranty of the manufacturer, weight content prior to packaging or the net weight, consumer complaint desk, consumer complaint desk, and all other information that fits the parameters of the consumer's right to information. Yeah, so let's have an example. We have Bear Brand Swak Pack. I know way back nung wala pang quarantine, nung nasa dorm pa tayo, nung nasa nabuboard pa tayo, ito, lagi nating binibili to. And I know that most of us have this in our boarding house. Yan. So, let's examine kung kumpleto ba ang Bear Brand sa labeling requirements. First, the trade name or brand name. We have the Bear Brand. Second one is the trademark. The trademark is the bear, the mark that distinguishes the product. And the next one is the net weight. Yan, we have here 33 grams as the net weight. Net quality of contents, which is the nutrition facts here. Business name, which is Nestle. Baka hindi nyo alam, ang Bear Brand ay Nestle. Yan. Consumer complaint desk address. This is important because should the consumer have any complaints, then you can easily contact the Nestle here. They have the contact number here and their address. And of course, the expiry date in this portion. The active ingredients. Also, the active ingredients are here. And then you can also see here that it is milk. So the active ingredient is also in front. So you can easily see that it is milk. And then country of manufacture is actually manufactured in the Philippines. It's kind of small, but it's there. And then the address of the manufacturer also in the Philippines. Yeah, and so we can say that Bear Brand Swak Pack is compliant with the labeling requirements under the law. Yeah. Okay, next parts of the label. This label of Bear Brand actually has its parts. Okay, we have the principal display panel, secondary display panel, and the literature. So what is the principal display panel? The principal display panel, as the law defines it, is that part of the label that is most likely to be displayed, presented, shown, or examined under normal and customary conditions of display for retail or sale, or that which is that is easily apparent or can easily be seen. So yun yung principal display panel. Ayan, Milo ulit. Mahilig ako sa drink, pambatang drink. Yan, Milo. Yan, this is the principal display panel. Yung usually it's the front part of the product. The next one is the secondary display panel. It is any part of the product other than the primary display panel. Yan. So any part, it can be at the back or in some places in front, yung hindi masyadong kita. That is the secondary display panel. The next one is the literature. The literature is this is more common in drugs. I mean, in ointments or medicines. You can see there the written something inside. That's called the literature. So it is also mandated, especially if masyadong mahaba yung mga nakalagay. So it cannot fit the packaging of the product itself. So it should be placed in the literature. Okay, what should be placed in the principal display panel? These three things are required by the law to be placed in the principal display panel. So we have the trade name or brand name, general make or active ingredients, the weight, net quantity or size. So we have the three: trade name, general make or ingredients, weight, net quantity. So let's examine the Bear Brand again. So we have here the trade name, it's in front. The net weight is also in front. And the active ingredients, excuse me, active ingredients, yeah, and we have here the milk, of course. And we also have here the zinc, iron, 100% vitamin C, it's in front. So Bear Brand Swak Pack is compliant with the things that should be placed in the principal display panel. All the other information or all the other minimum labeling requirements can be placed either in the principal, secondary display panel, or in the literature. So here, some other things are included in the principal display panel. Yan. And the others are here at the back. So that is just fine. That's okay under the law. And this enumeration are just a mere iterations of those that I have discussed earlier. Yan. So additional labeling requirements for certain products. We have flammable or inflammable products. So if the product is capable of burning, something like that, you have to place there the temperature that can trigger the burning of the product. And second, the precautions against accidental burning. So example here is this one. We have here the sign that it is flammable, and then the degree, 50 degrees, which is if the temperature exceeds 50 degrees, then the product might burn. Here are also examples of flammable products. Okay. The next additional labeling requirement is if the product requires direction for use. So read direction for use. There should be a direction. This one is a varnish or something like a foundation. It should have direction. And it can also be in food products. Yeah. How do you cook it? Something like that. So that's direction for use. Additional also for toxic substances or toxic products, we have a sign that indicates that the product is poisonous or it is toxic. Toxic na yung product ang toxic, hindi yung tao. Okay. So additional, it should be indicated here the manner by which said toxicity may affect a person. It can be when you eat it, when you inhale it, or even when you touch it, something like that. So also the possible symptoms of poisoning, the first aid treatment, contraindications when you ingested it, what can you not eat, and when is it crucial to take the victim to the hospital for treatment. And the next one is for corrosive products. Corrosive products are those that can burn the skin or can corrode the cement. It's really dangerous. So it should be placed in the package, in the labeling of the product, the first aid treatment. The food that cannot be eaten if you ingested it, or when is it crucial to have the victim. So it is basically the same with the poisonous product. An example of corrosive product is muriatic acid. So when you place it on your skin, it can burn your skin. And then insecticides or toxic products, because they are poisonous when you eat it or when you inhale it too much. When you inhale too much of it, it can cause irritation or damage to your body. And additional labeling requirements, also this is corrosive because sulfuric acid can actually burn your skin if you were not able to use it as per indication. So be careful. And all this should be placed on the labeling of the product. And one more is for limited use only. If the product is for limited use only, like for example, this cream for topical use only, it should not be ingested. So it should be indicated in the product. So you can see there that the product should not be eaten. It should only be for the skin. There. So now that you know the labeling, the minimum labeling requirements, are these labeling requirements applicable to all consumer products? And under the law is mahilig sa general rule and sa exception. Of course, generally, it is applicable to all. Syempre, may exceptions dyan. goods exempted from the labeling law. We have here first newspapers, magazines, periodicals, and the other reading matters are exempted because the contents of or a sample thereof may be inspected by the buyer upon purchase. The second one is if the consumer product is further retailed in very small quantity, like those sold in the public market. Where the third one is where the buyer himself provides the container for his purchase of a consumer product retailed in small quantities. So this is connected with the second one. So again, first, newspaper. Second is when it is retailed in very small quantity. And third, if the product retailed in very small quantity is being packed by the buyer himself. Yeah. So examples here, the newspaper, and then those that are sold in sari-sari stores, the repacked items. Yeah. So they do not, they need not follow the minimum labeling requirements under the law. So what are the prohibited acts on labeling? It should be prohibited to state there no return, no exchange, and of course, those in violation of RA 7394. Let's now go to fair packaging. Fair packaging means that the packaging of consumer products shall not be made in such a way as to cause the purchaser to be deceived as to the contents, size, quantity, measurement, or feel of the product. For example, this one. So parang kalahati lang ng packaging yung product itself. But let's see if this is compliant. First, let us discuss the non-functionally slack-filled packaging. Take note of this because this is a new term and this could be asked in the examination or in your examination. So what is non-functionally slack-filled packaging? The packaging of a consumer product shall be deemed to be non-functionally slack-filled if it is filled to a substantially less than its capacity for reason other than first, protection of the contents, second, requirement of the machines, third, inherent characteristics of packaged materials. You have to take note of this because not all products that are substantially less, that are filled with substantially less than amount of the product are called non-functionally slack-filled. So these products are slack-filled. So are they non-functionally slack-filled? The chips that we buy are actually the packaging of the chips that we buy serve a purpose because the air inside it actually protects the product from protects the quality of the product, so it can fall under number one. So we can say that these products, kahit na mas onte yung laman and mas malaki yung packaging, it is still compliant with the law. So what cannot be placed in non-functionally slack-filled packaging? Basic necessities, of course. Water. Imagine a bottle of water na kalahati lang yung laman. That's that is violative of this rule. So yung bottled water dapat more or less puno siya. As ganyan yung nabibili natin, more or less puno. So kapag may nabili ka na kalahati lang, malamang nabawasan na yon. So wag mo nang bilhin. The next one is artistic or aesthetic considerations. The pictures that you can see are actually artistic or aesthetic considerations, so long as it does not deceive the consumer and that it represents the contents of the product. Here, you cannot expect naman that a real potato is inside this chips. Syempre, chips yan, naluto na yan. So, it is a fair representation. Next, contents of packaged products cannot be inspected upon purchase. If that's the case, if you cannot see through the packaging of the product, the contents thereof, then Samples or pictures should be placed therein so that the consumer can see what is actually inside the product. Handling instructions, yan, very famous ulit to. Ingatan, wag ibagsak, especially during this online classes. Ingatan, wag ibagsak. And handle with care. Ito yung ingatan, wag ibagsak, ito yung prayer natin sa mga professor natin. So sana nakikinig sila. Next is the packaging of dangerous products. Dangerous products can be packed in such a way that accidents caused by it should be prevented. So it can be placed in a bubble wrap to prevent breaking. Yan. So the last one, I think the last one is special packaging for children. There are certain products that cannot be played or that cannot be handled by children. So in such cases, the packaging should include indications that it should be kept out of the reach of children. Yan. So in case of violations of these rules that I have discussed, there are certain penalties. So you as consumers, if you were able to buy a product or to see a product that does not conform to the minimum labeling requirements and fair packaging, you can actually report them here, and so that they may be subjected to penalties. So here, criminal penalties, we have here fine, imprisonment, or both. Administrative penalties, administrative fine can be imposed. Yan. And my advice to you is that label check, please. Always check the label. So do not buy products that do not have labels. And importante ang label. Again, ulit-ulit, alam mo yun, importante ang label. That's my advice. Yes, so that's all for labeling and packaging requirements. I hope that you were able to learn something from it, aside from the fact that you should always check the label. And thank you for listening. I hope that you will be able to use these learnings to in your examinations, especially in the licensure examinations. Thank you and good day.
Hello. So ayun, the previous two speakers were very comprehensive, no? And I'm sure ang daming natututunan ng ating accountancy students and graduates today. So so far we've done two lectures na. We're going to have a 5-minute break para i-digest yung information and maybe for a bathroom break. So we will be back in 5 minutes. Thank you. So hello guys. Uh okay na ba yung break natin? Were you able to digest na the information that we have learned in the previous two lectures? So if so, before we resume, syempre, we're going to post the promotional video for the School of Law. So maybe if you plan to go to law school, apply now in the St. Louis University School of Law. So um, let's resume. Let's now call on our third speaker for this afternoon.
So hello everyone. Good afternoon. And hello to you CPAs, of course. Syempre, as early as now, we have to call you that because, as they say, you attract what you always say. So um, For this webinar, I am tasked to discuss with you sections 50, 51, and the related provisions of RA 7394. These are the provisions which tell us what are deceptive acts or practices. Corollary thereto would be how these acts or practices are committed, by whom, and the punishment attached to these acts. Since we have a very limited time, let us move directly to the provisions. Section 50 reads that a deceptive act or practice by a seller or supplier in connection with a consumer transaction violates this act whether it occurs before, during, or after the transaction. An act or practice shall be deemed deceptive whenever the producer, manufacturer, supplier, or seller, through concealment, false representation, or fraudulent manipulation, induces a consumer to enter into a sales or lease transaction of any consumer product or service. Breaking down that definition, we see that deceptive acts may be committed by a producer, manufacturer, supplier before, during, or after the consumer transaction. And the means by which deceptive acts may be committed are, first, through concealment. That is when the seller purposely hides or conceals or prevents a material fact related to the consumer product to the buyer. Second, through false representation, wherein the seller will give out untrue or incorrect representations, descriptions, or statements about a material or important fact that, even if the seller knows that such fact is a lie. So third is through fraudulent manipulation, wherein the seller would employ means to control the buyer to do what he wants the seller to do, which is, of course, to enter into a sale or lease transaction. In excuse me. In the case of AUA Electronic Philippines versus DTI, the Supreme Court had the occasion to rule that while promotions, gifts, and giveaways are not per se prohibited, as this may form part of marketing strategies, the scheme which was done or employed by AUA of offering gifts is fraudulent because the gifts or giveaways are used as bait for the consumers to force them to buy their products. Kung meron sa inyo naka-experience nito sa Baguio, actually this case sprung from that situation wherein, alam niyo yung mga stalls sa Baguio wherein they give you products saying na it's for free, but when you accept it, they say na kailangan mo munang bumili ng products nila before they give you the giveaway. So, ganun po yung scheme na ganito. And it's a misrepresentation. So to reiterate, the aim of the seller in employing deceptive acts is to have a consumer enter into a sale transaction or a lease transaction. Remember that sale or lease transactions that do not involve consumer products are not covered under this law, and hence they are not punishable. So it is thus important to know what are consumer products or services. This is defined under the law as goods, services, and credits, debts or obligations which are primarily for personal, family, household, or agricultural purposes, which may include but are not limited to only this, like food, drugs, cosmetics, and devices. Um, Under the law, there is no definition given for household, family, or agricultural purposes. So we take them to mean their ordinary dictionary meanings. However, the law gives a specific definition for what are agricultural purposes, drugs, and cosmetics. So I encourage you to still read the definitions given under the law. So even if a seller commits all acts of deception in one single transaction, he may not be punished under this law if the object of the transaction is not consumer products. After knowing all those, we go now to the specific acts of deception enumerated under this law. So the items from the enumeration are actually very straightforward and are readily comprehensible. Self-explanatory, kumbaga. So I will just give examples to enforce your understanding of them. So under this provision, there is deception when the seller represents that a consumer product or service has a sponsorship, approval, performance, characteristics, ingredients, accessories, uses, or benefits it does not have. An example for this would be when a seller or a manufacturer of a drug or medicine for heart disease indicates that the drug is approved and sponsored by a renowned heart specialist to cure heart diseases, when in fact the manufacturer has never presented the drug for approval to the or sponsorship by the heart specialist. So that through the alleged approval, sponsorship, and claim that the drug cures heart disease, a buyer would be impelled to buy the drug or the medicine. So the next is, there is deception when a consumer product or service is of a particular standard, quality, grade, style, or model when in fact it is not. So to illustrate, for example, a consumer goes to a phone shop to buy a particular brand or model of phone. The seller, since he does not have that particular kind of phone, would present another phone of a different brand, quality, or model. The seller knows that the phone he offers as an alternative is not actually of the same kind or of the same quality with the phone originally being sought by the buyer. However, the seller, because he wants to sell the product, would claim that it is of the same quality or even a better quality than the first phone being sought. So in this case, there could be misrepresentation or even fraudulent manipulation because the buyer would be induced to purchase the alternative phone, considering that the seller misrepresented it to be of a quality that is the same to the um, to the to the first phone being sought. So uh, actually, if you saw the photo shared by our always pretty Dean, he sent a photo of the how do you call that in English? Salbabida, bought by Augie Alcacid, wherein in the picture it appears to be a very big floater. However, when it arrived, it's actually very small that it fits completely in the body of Augie Alcacid. This such kind of deception may fall under this particular provision. The next act of deception is when the seller represents that a consumer product is new, original, or unused when in fact it is in a deteriorated, altered, reconditioned, reclaimed, or second-hand state. This is very much relevant and applicable in online selling. For example, clothes, because this is very prevalent now, wherein the seller it's possible that the seller, in taking photos of the clothes for selling, would brighten up the light or arrange it in a manner that that the stains or other infirmities of the clothes would be hidden, or the seller could even claim that the clothes are brand new. However, in fact and in reality, it's actually second hand, or actually in a deteriorated state already. Another act of deception would be when a seller represents that a consumer product or service is available to the consumer for a reason that is different from the fact. An example would be when a manufacturer formulates a product and tag it as one which removes scars. So a consumer with scars will be compelled to buy it or induced to buy it. However, the formulation of the product actually is for purposes related maybe to healing of wounds, but not actually to eradicating of scars. Moving on, if a seller represents that a consumer product or service has been supplied in accordance with the previous representation when in fact it is not. A specific example for this is if B ordered, for example, 10 jars of wine from A. B was amazed how great the wine tasted. So B, the buyer, asked A, the seller, about it. And A, the seller, says that only fresh grapes are used in every creation or every time they make their wine. So upon such representation, B ordered again or would order again. So it turns out that the second batch of wine ordered by the buyer is not as good as the first batch. So the reason for this is that the grapes used in the second batch are actually not fresh. Here, there was a previous representation that the wines were made from fresh grapes, when in fact, in the second batch, they were not supplied in that manner anymore. Here, the seller represents that a consumer product or service can be supplied in a quantity greater than the supplier intends. An example for this would be when a seller would hype a product and offer it at a discount for a very limited period of time, thereby attracting a number of people who would want to take advantage on the promo and place their orders within such period of promotion. However, it could be possible that due to the uncontrolled number of people who would place their order, the supplier would not have enough stock to send to all the buyers. Especially if the seller does not have a good inventory system. Many of the buyers would then be made to wait indefinitely, or sometimes the seller would just deliver another kind of product which was not the one ordered. There's misrepresentation, the same specific product, timely, but actually does not receive it, or if he receives it, it is another product, or even not receive it at all. So another deceptive act is when a seller represents that a service or repair of a consumer product is needed when in fact it is not. So an example again for this is if a buyer buys a laptop from a seller, the laptop after being used for hours always start to whiz. So the buyer thought that the laptop has a problem in the internal fan. So when the buyer brought the laptop to the seller would say that the laptop needs to be repaired because the internal fan may be damaged, even if the seller actually knew that the wheezing is normal when the laptop has been used for hours. Well, this is an unlikely scenario, really. It's a technical matter, so it could be possible, and there is deception here because the seller conceals the fact that the wheezing is but normal and misrepresents even that a repair is needed, even when it is not. Next, the seller represents that a specific price advantage of a consumer product exists when in fact it does not. For example, A sells cleaning liquids. A claims that the suggested retail price for one bottle of a cleaning liquid is 500 pesos. So A now says that he will only be selling it for 300 pesos a bottle, or even at 200 pesos for bulk orders. However, the product is not actually regulated or has no suggested retail price. The misrepresentation and concealment is thus apparent. A did not disclose that there was no SRP. So instead, she makes a representation that the products are selling at an SRP of 500 to entice buyers to buy the cleaning liquids she's selling from her because she's apparently selling it at a lower price. However, it's actually the price she wants to sell the products. So another is when the seller represents that the sales act or practice involves or does not involve a warranty, a disclaimer of warranties, particular warranty terms, or other rights, remedies, or obligations if the indication is false. Usually, this is violated by sellers who have no business registration. They are also the ones who offer seemingly cheaper products, of course, because they do not offer warranties or unlike their counterparts who are actually duly registered. This is because they do not offer warranties along with their products. So the low price is because of the lack of warranty. Or if they do offer warranties, there's no clear instruction on how to claim the warranty. Or the warranty is but for a very short or limited period of time only. Sometimes what the seller would also do is to be very uncooperative when the consumer would claim the warranty. So lastly, the seller represents that the seller or supplier has a sponsorship, approval, or affiliation he does not have. This is similar to the first one we discussed, only that instead of the product, it is the seller who is supposed to have a sponsorship, approval, or affiliation that he does not have. An example for this is the current issue about Dr. Farah, for example. Dr. Farah claims to be affiliated with Harvard University Medical Group and sells a medicine, for example. However, she was not actually affiliated with Harvard University Medical Group. Nonetheless, through the alleged affiliation that she has with Harvard University, buyers would tend to buy her products because of the trust reposed to the competency of Harvard University. Basically, that's the last of the enumeration. However, Article 51 provides us with a seemingly catch-all provision wherein if an act is deemed deceptive by a consumer, but it is not among those that we have enumerated, the consumer may go to DTI. Why DTI? Because DTI is the implementing arm of this chapter in RA 7394. So the DTI would conduct a hearing after the parties who will be affected are notified. And after the hearing, they may declare that an act, practice, or technique is actually deceptive. So the enumerations we mentioned a while back is not exclusive. So committing deceptive acts under this law may be punished with fine, not less than 500 pesos, but not more than 10,000, imprisonment of not less than 5 months, but not more than 1 year, or both at the discretion of the court. Other reliefs may also be granted, such as injunction, in order to prevent the seller or the person committing violations of these acts or of this law or deceptive acts to stop from doing such acts, or actual damages in favor of the consumer who was prejudiced through the sale or lease transaction, or other orders in order to redress the injury suffered by the person or the consumer because of the deceptive acts. Substantially, we have covered deceptive acts under RA 7394. However, it is still prudent, of course, to read through the provisions under the chapter on deceptive acts in order to ensure that you have a gist on what the chapter really is, on the provisions included in that chapter. So with that, I would like to know or confirm if you have retained things from our discussion. I have prepared 3 multiple choice questions, and would give you 15 seconds to read and answer. So that's about the same time you answer one question in the board exam. So go. Done. You can send in your answers through the chat as well. Okay, so the answer is the first statement is true, but second statement is false, which is A. The second statement is not false because, as I have mentioned, the list under Section 50 is not exclusive. So the next question is, here, I'll just read it for you. A sold a beachfront house to B, even if A knew that the house was not actually fronting the beach. Second statement, A sold to B what was alleged to be methamphetamine chloride, or more commonly known as shabu. However, it turned out that it was not shabu but tawas. So the choices are A may be held liable for violating RA 7394 in the first statement but not in the second. B, A may be held liable for violating RA 7394 in both statements. Letter C, A may not be held liable for violation of RA 7394 in any of the statements. And D, A may only be held liable for violation of RA 7394. So kindly send in your answers in the chat box. In 5, 4, 3, 2, and 1. The answer is C, which is A may not be held liable for any violation of RA 7394 in any of the statements. This is because in the first statement, the object of the sale transaction is a real estate, which is not a consumer product. And in the second statement, actually, A is already committing a violation of another special penal law, which is the the drugs law. The next question is, a violation of Section 50 and 51 of RA 7394 is punishable with, actually, this is easy. So your answers in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. And I think all of you got this. The answer is B, which may be imprisonment or fine or both at the discretion of the court. So thank you very much for listening, and I hope you got something or you retained something from our discussion, which would eventually help you in answering questions which may come from this law in your upcoming bar examinations. And as early as now, I'd want to congratulate you already, future CPAs. Thank you very much.
And so thank you very much, Keisha, for the very comprehensive report, comprehensive lecture, I should say. So our next speaker has provided an audio lecture because of a video lecture because of internet connectivity problems on her end. So I'm going to present the video now.
Hello, fellow yellows. Good afternoon. Before we proceed to our topic this afternoon, please allow me to introduce myself. I am Karen Joyce Rosario, a fourth-year law student. Before law school, I was also a member of Pamilya Comercio. I graduated Bachelor of Science in Accountancy year 2012. So, hindi naman masyadong malayo yung gap ko sa inyo. We were on our third year, I guess, when we were transferred from Silang Building to Mary Heights Campus. So, yung batch namin, naranasan din naman namin kahit papano na tumapak sa Mary Heights Campus. Pero yung time namin, wala pa yung mga other facilities that are available right now. Like the swimming pool, wala pa yon. Ginagawa din noon, time namin, hindi pa ganon ka, hindi din, wala pang oval. So, yon yung nung mga time namin. Pero, nung time namin, uso na yung sisingit ka sa pila. Sa sobrang haba ng pila ng jeep, di ba? Uso na yon sa amin nun. So, I was tasked today to discuss with you Chapter 3 of RA 7394 or the Consumer Act of the Philippines. The principal law for consumer protection is Consumer Act of the Philippines or RA 7394. And one of the objectives of the law is to implement measures to protect consumers against hazards to health and safety. Actually, we are all consumers kahit yung mga richest of all the rich. They are themselves consumers from nasa mother's womb pa lang tayo. Actually, we are already a consumer and until our last breath, I believe we will all be consumers. So in this chapter, we will focus on hazardous substance and the prohibited acts provided and its corresponding penalties. So first, what is hazardous substance under RA 7394? Hazardous substance under RA 7394 is a toxic substance which may cause a substantial illness or a substantial injury, particularly or most especially to children. So we have to remember, guys, na pag toxic pala, hazardous. Ha? Okay, so another definition given under RA 7394 is it refers to any substance which the DOH finds to be under the categories mentioned in number 1. Third, any radioactive substance which is sufficiently hazardous to require labeling. Radioactive substance is unstable and produces dangerous kinds of radiation. Kasi 'di ba, may mga kind of radiation naman na hindi naman sufficiently hazardous like the light coming from our lamp or in the microwave. Pero yung radioactive substance na sufficiently hazardous is, for example, uranium. Uranium is used to produce electricity in nuclear power plants. And when uranium produces radiation, they also create a lot of heat, which makes it sufficiently hazardous. That is why the law provides that there should be a proper labeling. So, kailangan may label. So, check the label, mami, sabi dun sa isang advertisement. Check nyo daw yung mga label ninyo. Kailangan may label, di ba? Kasi hazardous. Check mo. Yun lang. So, kung na-check mo na yung label ninyo, okay. Kung may label nga ba, anyway. Last definition as provided under RA 7394 is that hazardous substance is any toy or other articles intended for use by children, which the director may determine the presence of an electrical, mechanical, or thermal hazard. Uh, uh, But the law, after giving that set of definitions, also gives a limitation on its definition of hazardous substance by stating that the term shall not apply to food, drugs, cosmetics, and devices, nor to substances intended for use as fuels when stored in containers and used in heating, cooking, or refrigeration system of a house. RA 6969 also, or the law on toxic substance, provides for a different definition on hazardous substance. And under that law, it says that it refers to substances which present either short-term acute hazards or long-term environmental hazards. So let us now compare the two laws on its definition of hazardous substance. If you can see, the definition of hazardous substance under Republic Act 6969 or the law on toxic substance is broader in its definition because it does not provide for limitation on its application. Unlike in hazardous substance under RA 7394, which it says there that it shall not apply to food, drugs, cosmetics, and etc. So, yun yung distinction nung dalawang law. They are referring to same hazardous substance pero different yung meaning nila. Going back to RA 7394, hazardous substance are further classified into two, namely banned hazardous substance and mislabeled hazardous substance. So, first, what is a banned hazardous substance? It refers to any toy or other articles intended for use by children which are hazardous per se. So, kung hazardous per se, there's no need na i-declare pa ng DOH or any implementing agency na this kind of article or this toy is hazardous. Kasi hazardous na siya on its own parang hindi mo na kailangan pang i-declare or coming from a appropriate authority na this product or this article is harmful to human beings kasi nga hazardous per se na siya. Or banned hazardous substance is any hazardous substance intended or packaged in a form suitable for use in the household. On the other hand, mislabeled hazardous substance is any hazardous substance which is in violation of the special packaging regulation. So there is a violation of the special packaging regulation when such substance fails to bear a label which states conspicuously the following. So, ang first na gagawin natin is to check the label. Ngayon, kung may label, ang next step is to determine if yung label ba kitang-kita. Baka may label nga pero hindi naman nilagay doon sa conspicuous place where a consumer can apparently see it. Parang yung font na ginamit ba or yung kulay nung printed materials, baka hindi siya kitang-kita doon sa article mismo. So, first, check the label and tignan mo. So, nadagdagan na, check the label. Tapos, next step is to check kung yung label na yon kitang-kita ba. Kasi baka yung label na yon kayong dalawa lang nakakaalam.
Siyempre, wala na akong internet.
Yon.
Out na.
So, these are the following labels which are stated in the article. So, mga tulad kanina, yung word na caution, yung word na danger na dapat ilagay, and instructions for first aid, treatment if necessary, the word poison for highly toxic substance, and yun nga, yung statement din na keep out of reach of children. Ano yung mga example ng mga products na nakikita natin sa market na may mga ganitong labels? Marami eh. One thing that I can think of is yung fire extinguisher. Meron yung mga ganyan yung statement, keep out of reach of children, mga ganon na label doon sa product mismo. The law also provides for the regulations on imported hazardous substance. So, why is there a need to regulate imported hazardous substance? Kasi may mga to do away. Ang purpose nung batas is to prevent our country from being used as a dumping site. Kasi baka ang pwedeng mangyari dyan is may mga banned na hazardous substance from a foreign country, and to avoid the destruction kasi pwedeng i-order ng foreign country na i-destroy nila yung product na yon or yung article na yon. So, to do away with that destruction, the manufacturer or the seller might as well, instead of incurring higher loss, might as well dump it here in the Philippines and sell it here in the Philippines at a lower price maybe. So, para lang i-minimize nila yung loss nung business nila. So, in order to avoid that from happening, the law provides for regulations para hindi naman tayo yung kawawa dito sa Pilipinas, tayong mga consumer dito sa Pilipinas ang magiging kawawa. So first step, as provided by the law, is the delivery of the samples to the Department of Health for examination purposes. And we must also notify the owner or consignee to in order for him or her to exercise her right to make testimony. The next step is to conduct examination. After examination, there can be three possible findings. First, the DOH may find that such hazardous substance is mislabeled or banned, or that the hazardous substance can be made to comply with the requirements provided it will comply with the relabeling or other action or order that the department may find necessary or appropriate, or that such hazardous substance complied with the requirements of the law. It is possible also that pending decision on its admissibility, the Commissioner on Customs will authorize the delivery of such hazardous substance to the owner upon execution of a ban. So parang ibabalik yung article na yon sa owner, sa may-ari. So walang findings na nangyari. Hindi natin alam kung ma-admit or hindi ma-admit yung product. So kung i-market ulit natin yung gusto ng manufacturer na i-market niya ulit yung product niya na yon or yung article niya na yon, he or she should undergo on the procedure, hindi pa wala pang findings dun sa product niya kung admitted ba or hindi. So mag-undergo muna siya sa examination. Hindi pa tapos yung proseso ng article na yon. Wala pang findings. So what are the consequences of those possible findings? Number one, the DOH can refuse its admission and cause the destruction unless it is exported within 90 days from notice. It can also order the deferral of its admission. Parang mag-comply muna. After the compliance, kapag comply na yung manufacturer, and upon filing an application and execution of a bond, i-admit na yung article. And if from the findings of the department, the hazardous substance was in compliance with the requirements of the law, then it will be admitted. The law also enumerates 5 prohibited acts under this chapter, and these prohibited acts are in furtherance to the main objective of the law, which is to protect consumers. In addition to that, this list of prohibited acts will establish a standard of conduct on the part of our manufacturer, dealer, or seller. Thus, strict compliance to the standards is a government concern that would ensure the safety and protection of consumers. However, we should not lose track of the fact that the ultimate beneficiaries of these product standards are consumers, be it industrial, food, and drugs. For its penalties, any person who violates any of these prohibited acts shall be subject to a fine of not less than 1,000 pesos or an imprisonment of not less than 6 months but not more than 5 years, or both upon the discretion of the court. However, no penalty shall be imposed upon the following. Number 1, any person who violates paragraph C of Article 46. The requirement, however, is that he should furnish the name and address of the person from whom he purchased such hazardous substance. And number 2, any person who violates paragraph A of Article 46. And for its exception, he shall establish a guarantee or undertaking signed by and containing the name and address of the person from whom he received in good faith the hazardous substance, to the effect that the hazardous substance is not a mislabeled or banned hazardous substance. My topic, that is Chapter 3 of Republic Act 7394. Thank you for accommodating me. And I have prepared here 3 questions for your review and posted also its suggested answers. But before I will end my presentation, let me share to you the same message of Sir Dayag, one of the reviewers during my time of a prominent review center in Manila. There are things in life that you can control and you cannot control. You focus on the things that you can control and forget the things that you cannot control. Because those things that you cannot control, you leave it to God. Because to us human beings, there are things that are impossible. But to God, all things are possible. So that's it. God bless future CPAs. And, sometimes a delay in our plan is God's protection. You may not figure it out right now, but sooner or later you will understand. Thank you again.
Okay, guys, so that's the presentation of Ate Karen. Nico, can you hear me? Are you hearing anything? Do you
Yes,
hear what I
hello.
say? Okay, okay. Okay, gising pa ba tayo? Mukhang... Hi, Adings. Gising pa ba tayo? Okay, okay. Salamat, Vic, Cha, Kesha, and Ate Karen for presenting those relevant topics, which I believe it's very important not only for those who will be taking the SIPALE, but also for us as consumers and as, of course, Filipino citizens. So ngayon naman, sige, wait, let me share my screen. Okay. Do you see my screen, Nico?
Yes po. It's very,
Guys?
medyo blurred, pero okay lang. Readable
Nakikita ba?
naman.
Okay, sige. I will tackle about Price Act, so the price tag law. So, bakit importante itong Price Act or the price tag? Apart from you taking the CPA board exam na incorporated na siya ngayon, syempre, as Filipinos, it forms part of our rights, di ba? Kailangan nating malaman to. So, since we are getting educated with this topic, guys, let's beat ignorance kasi maraming hindi nakakaalam nito. Okay? So, what are the governing laws dito sa discussion ko? First, we have Section 81 to Section 83 of the Consumer Act, which were discussed a while ago by Cha and Vic. And then, next is RA 7581 as amended by RA 10623 or the Price Act itself. So punta muna tayo doon sa first part, which is sections 81 to 83 of RA 7394. So dito, sinabi yung price tag requirement, but rather in-enumerate ng law kung ano yung mga prohibited acts, which were dalawa yung sinabi doon. So first, we have selling without price tag, label, or marking. So as we observe, maybe some of us have encountered some situations wherein punta tayo sa grocery and then walang price tag or walang label or walang marking yung product na binibili natin. Actually, that's a blatant violation of the law. May natry akong bakery supplies, nagsusupply ng baking products dyan sa Baguio. But anyway, hindi ko nasasabihin. Baka delikado tayo dyan. Okay, so next prohibited act is selling a product which is at a higher price than that indicated in the price tag. So here is an actual example, okay? Dito, I actually got this image from a blog na yung mother, bumili siya ng damit ng anak niya na nakalagay dun sa tag niya is 200 pesos. But then, nung nagbayad siya, nakita niya sa resibo, it's 300 pesos. So imagine the price difference of 100 pesos. Ang laki nun. That's a blatant violation of the law. The seller must be held liable. Okay? So, under the same section, however, kung meron sa atin dito nagsusupply ng mga lumber, yung mga tabla, ganon, apart, na-indicate kasi dito sa batas ni-specify nung batas, sabi niya is, apart from the price, the official name of the wood must be indicated. Bakit kaya? Maybe the rationale of the law behind this is that, di ba ang wood kasi is ginagamit sa pag-build ng bahay, infrastructures, and anymore, etc., yung mga gamit sa bahay. Maybe yung pangalan ng wood or official name of the wood is indicative of its quality. So it's very important to put therein the name of the wood. Okay? However, siguro naisip nyo, lahat ba kailangan may price tag? The law also provided exceptions, of course. Kasi sabi dun dito sa law, if it's too small or impractical na lagyan mo ng price tag isa-isa yung product, it is sufficient na maglagay ka lang ng price list dun sa nearest point niya. So, imagine this, kung nagbebenta ka ng munggo or rice, bigas, alangan lagyan mo isa-isa ng ng price tag yung yung butil. So it is sufficient na lagyan mo sa tabi ng rice ng price niya, which is siguro 50 pesos per kilo, 45 pesos per kilo, ganon. That's sufficient compliance with the law. Okay? So, this is actually section 82 na in-indicate din sa batas kung paano maglagay ng price tag. So, it must be written clearly and the price must be indicated in pesos and centavos. So, here's an example. Nakikita natin, this is an example, price tag siya ng SM na naka-indicate yung price in peso and pati yung centavos niya. So, this is a good job for SM. Pero, hopefully, they stop cutting trees. Okay, anyway. Oh, here. Do you see something wrong with this? I actually screen cap this from Facebook na may nagbebenta dito sa amin ng divider. Do you see something wrong here? There is, di ba? Kasi PM sa price. Ang dami-daming nagva-violate nito, di ba? Sa Facebook pa lang, PM sent or PM Sismars, ganun, nakakairita. Apart from nakakairita, they are violating the law. So, since may knowledge na tayo about this, na bawal tong ginagawa nila, maybe we could educate them. Sabihan natin na, uy, Sismars, bawal yung ginagawa mo, dapat ilagay mo yung price. Okay? So, section 83 indicated here in that the concerned department shall prescribe rules and regulations. Yung concerned department na sinasabi dito sa batas is actually the DTI. So, dito, the DTI has power or regulations of prices, products, and other circumstances or other yung mga trade and industry matters natin sa Philippines, DTI ang may control niyan. Okay? So next, we go to RA 7581 as amended by 10623. So ito yung Price Act mismo. So what do we need to know about this? Ang ginawa ko for this discussion is hinati ko siya. Hinati ko siya sa dalawang portions based sa basic policy niya. So yung first sa basic policy is it talks about reasonable prices. Dapat it ensures that basic necessities and prime commodities were at reasonable prices. And of course, without prejudicing the legitimate business affairs of our merchants. And secondly, actually this is a penal provision tanang against hoarding, profiteering, and cartels. I believe medyo familiar na kayo dito, so we will elaborate this later. Okay? So for us to know the contents of this law or kung ano yung sinasabi ng batas na to, we should know first kung ano ba ang mga basic necessities and prime commodities. So remember these two ha, basic necessities and prime commodities. So for basic necessities, makikita nyo to sa section 3, paragraph 1. Okay, that's paragraph 1 of section 3. It includes rice, eggs, sugar, milk, kape, ganun. These are the products which under the words of the law were described as products vital to the needs of consumers for their sustenance and existence. So alam natin to yung mga daily na kinakain natin. Ito sila, basic necessities. Okay? And next, we have prime commodities. So believe it or not, ang papel, prime commodity siya, under siya sa list. So, yung list nito is under paragraph 8. Yeah, that's paragraph 8 of section 3. You can see the complete list. But examples of this would be ito, yung flour natin, and then yung cement. Yeah, that's form part of the prime commodities. Okay? So, bakit natin kailangan malaman kung ano yung mga product na kabilang doon sa basic necessity or prime commodities natin? Well, it is because itong mga product, kung may mangyari sa country natin or may event or circumstance na mangyari sa country, magti-trigger yun price control or price ceiling. So kunyari dito sa okay, but before we go into that, let us first know what is a buffer fund. Very important tong buffer fund. Siguro may idea kayo kasi buffer from the word buffer. Ito is part to ng budget ng DTI. So yung illustration dito is, kunyari nagka-shortage tayo ng rice. And then wala tayong mapagkukunan ng rice. Our only option is to import from Vietnam. Kunyari Vietnam, malakas sila sa rice eh. Tapos yung rice nila, 75 pesos per kilo. In contrast sa atin na 50 pesos per kilo. Supposing 50 pesos per kilo. Ang mangyayari doon is import ng DTI yung rice ng 75 pero ibebenta sa mga Pilipino ng 50 pesos at the prevailing market price. Para naman hindi kawawa ang mga Pilipino, di ba? So yeah, that's one benefit of being a Filipino. We are protected by our laws. Okay? Yun yung buffer fund. Yeah, that's an emergency fund actually. Pero yun lang yung purpose niya for the Control of Price Act. Hindi siya pwedeng gamitin sa ibang purposes ng DTI. Solely for purposes of Price Act lang yun. Okay? Chikahan muna tayo konti. Alam nyo ba na actually wala tayong buffer fund sa Pilipinas? Medyo kawawa naman tayo konti. Nag-research ako and this is what I saw. From the past years up until and even yung next na proposed budget natin for next year na 5.3 billion for DTI, walang nakaano doon na buffer fund. So yung isang kongresista yata natin is nasabi we should dapat may portion para sa stockpile lang ng basic commodities and pati basic commodities including PPEs and face masks. So maybe nagtataka kayo bakit ang face mask na wala naman sa listahan natin kanina sa list ng prime commodities or basic necessities pero bakit isa-subject siya sa Price Act? Well, pwede siyang include actually sa listahan natin. Especially ngayon na COVID, para nagiging necessity na natin ang mask, di ba, or face shield. So, ang mangyayari dito is, yung DTI magkakonduct ng public hearing to determine if indeed pwedeng include ang face shield or face mask sa listahan ng prime commodities. And with the approval of the President, so yung role ng President natin dito is very important. Pag in-approve niya ito, may include siya sa basic prime commodities natin sa listahan. So, pwede siyang masubject sa price ceiling or price control. Okay? So, punta tayo sa automatic price control. So, ano ba to? Ano ba yung mga events sa country natin na kapag trigger ng price control? So, under the law, may 6 na circumstance ito. So, eto, pag nangyari tong mga to, yung mga products na binibili natin, ma-freeze yung price niya. So, bawal, taasan ito. Kasi prevalent to nung kasagsagan ng COVID, nung March, up until now, actually, may mga overpriced tayong products, which is yung mga sellers natin, nagahaman, nagbabiolate ng law. So, ano tong mga events na to or circumstance na to? First, we have pag nasa state of calamity tayo. Like today, pursuant to, if I'm not mistaken, Proclamation number 929, which was extended last September, up until now, nasa state of calamity tayo. Next, pag under state of emergency tayo. Sorry. Okay. And then next, pag yung privilege of writ of habeas corpus natin is suspended. So, maybe foreign sa inyo tong writ of habeas corpus. So, a konting explanation nito is that ito, writ to na ini-issue ng court against a particular person or a government official to produce the body of another person who was detained. Para i-determine ng court kung valid ba, kung legal ba yung pag-detain mo sa isang tao. That's the purpose of writ of habeas corpus. And actually, it will be elaborated pag nag-enroll kayo sa School of Law. Marami kayong matututunan. Life-changing, tsaka nakakaganda. Mapuprove naman natin sa mga speakers natin, kay gaganda at kay gagwapo namin, di ba? Sa din pa lang namin, sobrang ganda na. So, ayun, living proof kami na nakakaganda ang School of Law ng SLU. Kidding aside, let's go to the fourth instance, which is martial law. So, pag nasa martial law tayo, Yan, eto, mag-trigger din siya ng automatic price control. And the fifth and sixth is pag may state of rebellion and pag may state of war. So kung nangyari tong mga to, matitrigger ang automatic price control. So let me give you an illustration. Di ba nung dineclare ni President Duterte nung March na nasa state of calamity tayo due to COVID, nag-freeze yung prices. Let's say for example, itong sugar. Di ba kahit nag-panic buying yung mga tao kasi lahat nag-panic, literally nag-panic. So nag-panic buying yung mga tao, tumaas yung demand, pero yung prices natin, kunyari ng sugar, is still nag-stay ng 47. Actually, yung ibang sugar, depende sa brand kasi may mga mas mahal yatang asukal, yung mga branded, mas mahal sila onte. Anyway, yung prevailing market price nun, 47. So yung bili ko ng sugar namin nung January, before nung state of calamity na 47, up until now, kailan ba ako bumili ng asukal? Kahapon yata, still 47. So yun yung effect ng automatic price control. Okay? I hope you got that. However, may mga instance, tingnan natin, na excessive or unreasonable yung prices. So, ang mangyayari dito, kunyari dun sa asukal problem natin kanina, kunyari ang prevailing market price niya is 75, which is very excessive or unreasonable kasi ang SRP ng asukal is 45 eh. So, ang mangyayari dito is, kasi na-determine ng agency ng DTI na it's very excessive, kawawa ang mga Pilipino. So, ang gagawin ng DTI, mag-recommend siya sa President na sabihin, hey, Mr. President, sobrang mahal yata itong asukal natin. You might want to impose a price ceiling for sugar. So, ang gagawin ni President, mag-i-impose siya ng maximum price for that. So, let's say 50 pesos, at least reasonable, di ba? Afford ng mga Pilipino. Yan. Okay. Next, we go to price ceiling or the mandated price ceiling. So, as gleaned from the word itself, alam natin na this is the maximum price na pwedeng i-impose or i-price sa isang product. So, kung kanina may nag-trigger for automatic price control, meron din of course for price ceiling. May 5 instances tayo and yung number 1 and number 2 natin dito is parehas. Same doon sa first and second din doon sa kabila. And in addition to this, we have the widespread of illegal price manipulation, which is, sorry, maano natin mamaya, sa hoarding, profiteering, and cartel. And then next, pag may impendency, which causes artificial or unreasonable increase in price. And then lastly, pag yung commodity has fall levels. Sorry. So, nag-gets natin itong dalawang circumstance na to. Pag yung seller na find out na nag-violate neto nung kunyari, yung sugar problem natin kanina is yung seller, binenta niya pa rin at 75. Automatically, in violation siya ng price ceiling. May corresponding penalty ang law for that, which is 1 to 10 years imprisonment or a fine of 5,000 to 1 million. So, kung kayong may sari-sari store tayo, be wary of the prices. Wag nating i-take this opportunity na magmahal ng presyo kasi COVID crisis. Instead, mag-stick tayo sa provision ng law. Kasi ang law, ang batas, hindi nag-stop yan kahit crisis. Okay? So, punta tayo dito sa illegal acts of price manipulation. Ito yung na-embody dun sa second na basic policy natin. So, under this, may tatlong acts tayo na napipinalize ng law, which are hoarding, profiteering, and cartel. Okay? So, sa hoarding, di ba lagi natin tong naririnig sa news pag usually rice ang hino-hoard yung mga rice tycoons natin laging nag-hoard ng rice para in case umakyat yung presyo, dun lang sila magre-release. Actually, that's a blatant violation of the law and unbelievably, ang daming gumagawa niyan. Okay? So, eto nakikita niyo sa screen niyo, these are the elements ng hoarding. First, kung may undue accumulation ka, yung beyond your normal inventory level. So, kunyari, ang daily inventory level mo is 100 sacks per day. Tapos biglang bukas 300. Tapos ayaw mo mag-release, ayaw mo magbenta. Tapos hindi justified yung pagkuha mo nung rice. Kunyari, hindi ka naman nag-expand ng business or hindi ka naman nag-branch out. So, unjustified, di ba? So, there is a prima facie evidence of hoarding against you. So, that's very hard to overturn sa court. So, ingat-ingat sa pag sa stock or inventory. Okay? Next, we have profiteering. So, dito sa profiteering natin, ito yung nakikita natin actually until now, may nakikita ako, na yung price ng benta natin in excess of its true worth. Let's say, for example, sa alcohol, nung March, naalala ko, bumili ako ng isang 1 liter ng alcohol ng 250 pesos. Imagine that. Actually, ang 1 liter ng alcohol is 80 plus, 80 to 100, sabihin mo na. Na profiteer, tama ba? Nabiktima ako ng profiteering. Kasi in excess ng true worth nun eh. So, ayun, bawal yun. Don't do that if you're selling. Don't take this opportunity to manlamang sa kapwa. Okay? There is prima facie evidence of profiteering pag nagbebenta ka ng product na walang price tag. Walang price tag, tapos may representation sa weight or measurement, or the product is adulterated or diluted. Adulterated or diluted, for example, sa alcohol na haluan ng tubig, so imbes na 90% alcohol na lang, naging 10% na lang, that's profiteering. And whenever nagbebenta ka lastly, number 4, nagbebenta ka ng product which is 10%, mas mahal siya ng 10% kesa nung last month. So, I believe ang daming naka-experience nito, especially sa mga yung mga surgical mask. Ang daming gumawa nito since nung COVID. However, hindi lahat ng products na nag-fluctuate yung price is under profiteering kasi nag-provide ang law. Kasi parang it's common sense naman. Kunyari for these products, agricultural crops, fresh fish, fresh marine products, and other seasonal products. Kasi, kunyari yung mangga, di ba? Kung season niya during the summer, di ba ang mangga as low as 5 pesos per kilo. Pero ngayon, na off-season na siya, as high as 150. Parang may nabili akong 150 no
Hello guys, sorry. May onting technical difficulties ata si Ate Jobs. For this Okay na? Okay ka na, Ate? Nakamute ka. You're muted. You're muted, Ate. I-unmute mo muna yung sarili mo.
Okay, sorry. Saan ako nag-end? Hindi ko napansin. Sorry, nawala yung
Mga lang naman, mga 20 seconds siguro.
So nasa cartel pa rin ako?
Yeah.
Doon ata sa part na adulterated yung sa alcohol.
Okay. So profiteering. Okay. Balik tayo doon konti. I-share screen ko ulit, ha?
Doon sa may...
be patient, sorry. Profiteering? Okay.
Kwentong mangga.
Yung sa mangga.
Mangga. Okay, sige. I-share screen ko ulit, ha? Be patient, sorry. Ang lakas ng ulan dito. Buti nga may internet pa ako ngayon. Chika muna tayo. Okay. Are you seeing my screen na?
Yes, okay na.
Okay. So, saan tayo sa mangga? Okay. as I've said a while ago sa mangga, di ba seasonal product yan? So pag season niya, usually May, April, May, June, July, ganyan kasagsagan ng mangga yan. As low as 5 pesos, you can buy that. Pero ngayon, na off-season na siya, may mga iba nagbibigay ng 200, 150. Pag nakakita kayo ng ganon, huwag niyong anuhin, huwag niyong duruin, hoy, in violation ka of the law kasi ang mahal-mahal ng produkto mo, 5 pesos lang yan eh. Actually, reasonable naman yon. Justify yun ng law. Kasi, seasonal yung product, justified yung product na mahal siya kasi out of season. So yeah, the law provides for those instances. Okay? Next, we go to cartel. So sa cartel, prominently naririnig natin to kami ni Kesha kasi since kaming dalawang tasa Ifugao, kunyari moguls kami. Tapos kaming dalawa lang nagsusupply ng gasolina. Tapos kailan ba ako lang nagpagasolina? Kahapon yata, 42 pesos ang gasolina, 42 pesos. Tapos kunyari mag-uusap kami ni Kesha, uy Mare, sis Mars, gawin nating 75 bukas ha. Walang magbibilaw ng 75 ha. That's a prima facie evidence of commission or engaging of cartel against you. That's very dangerous kasi pinapunish ng loto. So kung may gasolinahan kayo, wag niyong gawin yun kasi that's nanggugulang kayo sa kapwa, punishable yun. So kung in violation kayo ng tatlo, profiteering, cartel, and hoarding, pwede kayong ma-imprison ng 5 to 15 years and 5,000 to 2 million. And yun so very mabigat to, so don't do that. Actually, don't do anything bad. Kasi talagang everything is penalized by law. So, this would conclude my discussion about price tag or the price act law. I hope may napulot kayong lesson dito which you can use sa schooling nyo and then sa board exam nyo sooner or later. And then of course, as consumers, i-educate natin yung mga uneducated sellers natin kasi marami hindi nakakaalam nito, di ba? So, ayun. This ends my discussion. Salamat sa pakikinig and let's move on sa mas exciting na topic natin.
Thank you so much, Ate Jobs. No, very engaging yung discussion. I know it's 3:30, pero we just have one last lecture na for today to complete the lecture series for the Consumer Act and Consumer Rights webinar/review session for this afternoon. So, wag na nating patagalin pa, no? Let's welcome Irish, our last speaker, but definitely not the last for today. Thank you.
Ayun. So, ayun. Okay na? Meron ba?
Yeah.
Yes,
Okay.
meron.
So, mag-share muna ako ng screen, no? Yan. Share. Nasi-share na ba? Meron na?
Okay na, okay na.
Okay na? Okay. So, good afternoon, everyone. So, I'm your Ate Irish. Actually, lahat kami dito, kaming 6 na speakers, were actually previously part of Sub-M pa before. So, yun, proud Sub-M, Pamilya Komersyo. So, for this afternoon, I will tackle about Republic Act number 10642, or commonly known as the Philippine Lemon Law. So, ito ang overview natin. May short legislative history, purpose of the law, scope and coverage of the law, as well as availment, remedies, and penalties. So, sa short legislative history, this law is actually a consolidation of Senate Bill number 2011 and House Bill number 4082. It was approved and signed by then President Benigno Aquino III on July 15, 2014, and became effective on August 7, 2014 after its publication. And by virtue of Department of Order number 14-3 series of 2014 of the Department of Trade and Industry, the implementing rules and regulation was issued on November 17, 2014. So ang full title ng Republic Act na ito is actually an act strengthening consumer protection in the purchase of brand new motor vehicles. So, bakit nga ba siya tinawag na Lemon Law? So, noong 1800s, yung mga tao noong 1800s would actually describe others who were unfriendly, sour, or unpleasant as lemons. And in 1909, it was first recorded as an American English slang word to describe a worthless thing. And over time, the term lemon became associated with any broken or defective object that constantly breaks down, especially cars, hence the term lemon car. So let's now go to the purpose of the law. The purpose of the law is embodied in the first paragraph of Section 2 thereof, which contains the declaration of policy and provides that it is the policy of the state to 1. Promote full protection of the rights of consumers in relation to the sale of motor vehicles against any business, trade, or practices which are considered deceptive, unfair, inimical, contrary, or unfavorable to the interests of the consumers as well as the public. Wait, let's go back to that one. And aside from the purpose of the law, the same section also contains the rationale or the reason behind its enactment, in that the state recognizes a motor vehicle as a major consumer purchase or investment dahil sa taas ng presyo ng pagbili ng mga bagong sasakyan. Hence, it has the duty to protect the consumers by clearly defining their rights as well as providing them the means to redress any violations thereof. As for the scope and coverage of the law, it is provided for by the law under its Section 4. But in order to understand the matter more easier, I have divided the requirements into 3 aspects, which are: first, what are the type of vehicles that are covered? Second, the period of coverage, and the last is the kinds or defects the kinds of defects or damages that are covered. So let's now go to the first aspect. For the first aspect, which is the type of motor vehicles covered by the law, aside from the provision of Section 4, it must be read also together with those under Section 3, which provides for the definition of terms, specifically paragraphs A, D, and J. So, to combine those paragraphs, what are now the requisites for motor vehicle? First, a motor vehicle should be brand new. So, paano mga ba siya mo-consider as brand new? It should be constructed entirely from new parts. Second, it should be covered by a manufacturer's express warranty at the time of purchase. So, ang express warranty is by the manufacturer. Third, it has never been sold nor registered with the DOTC or the Department of Transportation and Communications or any appropriate agency or authority. And lastly, it has never been operated on any highway of the Philippines as well as on any highway of any foreign state or country. The next requisite for a motor vehicle is an authorized seller. So, sino nga ba ang authorized seller? Ang authorized seller can be an authorized distributor, dealer, or retailer in the Philippines. Dito, binanggit din na authorized seller ka kahit nagtitinda ka for cash or credit. The third requisite is self-propelled. Self-propelled, in a sense na hindi niya kailangan ng manpower, kundi may sarili siyang source of power like the gasoline and the batteries. And the fourth requisite is four-wheeled road vehicle. Ito ang requisite na self-explanatory. Kailangan may 4 na gulong yung sasakyan mo. at pangkalsada lang siya. Hindi siya pang riles, pang tubig, at lalong-lalo na hindi siya pang himpapawid. And lastly, ang main purpose dapat ng motor vehicle to qualify for the Lemon Law rights is for carriage of passenger. Pero hindi ibig sabihin nito na dapat exclusive lang siya for carriage of passengers. Pwede pa rin naman siyang gamitin for carriage of cargos. So, next, motor vehicles. So, the law expressly provide those that are covered and not covered. So, tignan natin. Ang covered ay sedans, coupes, station wagons, convertibles, pickups, vans, sports utility vehicles, as well as Asian utility vehicles. Take note, however, na itong list na to is not exclusive in that as long as a motor vehicle can satisfy all the 5 requirements we have previously discussed in the previous slide, pwede pa rin siyang mag-fall under the coverage and protection of the said law. As for those not covered, it was also well provided by law, such as motorcycles, delivery trucks, dump trucks, buses, road rollers, trolley cars, street sweepers, sprinklers, lawn mowers, and heavy equipment. Parang ay same din siya sa covered na ang list na ito is hindi exclusive. So kung titignan nating mabuti, yung mga sasakyan na hindi covered, ang common denominator nila is that meron silang at least isa dun sa mga 5 requirements na hindi na-complyan or na-satisfy. Kaya hindi sila naging covered. So, ngayon, para matandaan nyo kung ano ang covered at hindi covered, kayo nang bahala kung anong gusto nyo i-memorize. Kung yung listing ba na pre-provide sa law, or ang i-memorize nyo na lang is yung 5 requisites for motor vehicle coverage. So the next aspect of coverage is the period. So ang requisite naman nito is it can be availed of by consumers within 12 months from the date of original delivery to the consumer, or up to 20,000 kilometers of operation after such delivery, whichever comes first. Underscored is the word "or" in this presentation so that ma-emphasize natin na compliance with any of the two is sufficient. So, last aspect of coverage is the defects or damages covered. So, ang requisite naman nito is that it only covers non-conformities with the vehicle's manufacturer or distributor's standards or specifications. So, ano yung tinutukoy ditong non-conformity? It was well provided under Section 3 of Paragraph K of the law, in that a non-conformity is any defect or condition that substantially impairs the use, value, or safety of a brand new motor vehicle, which prevents it from conforming to the manufacturer's or distributor's standards or specifications, which cannot be impaired. So, medyo broad enough siya to covered. However, yun yung general rule. There are also exceptions na may mga non-conformities na hindi covered by law, which are those non-conformities caused by the following. First, non-compliance by the consumer of the obligations under the warranty. So every time na bumibili tayo ng mga product, usually meron tayong terms and obligation na sinasabi sa atin para ma-avail natin kung ano yung mga warranties. So once na hindi ka nag-comply doon, hindi mo na pwedeng i-avail yung warranty. Next, modifications not authorized by the manufacturer, distributor, authorized dealer, or retailer. The third one is abuse or neglect of the brand new motor vehicle. And lastly, damage to the vehicle due to accident or force majeure. So, So as for the three classifications, papansinin natin, ang reason behind such non-coverage by law is that all those causes of non-conformity are attributable to the actions or inactions of the consumer. Hence, it is but proper na ang magsasuffer is si consumer and not the manufacturer, the distributor, the dealer, or retailer. As for the last classification, such nonconformity are caused by those which are beyond the control of the manufacturer, distributor, dealer, or retailer. So, tama lang ay justifiable naman na hindi dapat siya ma-prejudice sa mga wala sa kakayahan niyang kontrolin. So next, mabilis ba masyado magsabi lang po? So next is the availment of lemon law rights na. So may requisite po siya as to the number of repair attempts, in that before one can avail of the rights and protection afforded by the lemon law, the consumer must first satisfy the requirement of at least 4 repair attempts, all of which shall be within the period of coverage. And provided under Section 7 of the law as well is a final repair attempt to afford last opportunity to the manufacturer, distributor, dealer, or retailer to address the complaint of the consumer to his, her, or its satisfaction. Hence, a total of at least 5 repair attempts must be complied with before filing a claim to the DTI to avail of lemon law rights. So, ano ba ang one repair attempt? The definition of repair attempt and its process are both expressly provided in the implementing rules and regulation of the law. However, let's just focus on the process. So, the process consists of 7 steps. So, we'll discuss one by one. So, first is the consumer to bring the motor vehicle to the manufacturer, distributor, authorized dealer, or retailer, MDADR version, para mas madaling nakakabulol and report or demonstrate the complaints. So after ma-receive ni MDADR yung motor vehicle, kailangan mag-record siya. May record siya ng complaint na sinubmit sa kanya ni consumer. Pagkatapos nun, kailangan ipaalam ni MDADR to consumer or authorized representative kung ano yung mga proposals niya as to the repairs na gagawin niya dun sa sasakyan, as well as yung estimated time niya to complete such repairs. After making known those facts to the consumer or authorized representative, the latter should authorize the former to do such repairs by signing a repair or job order. And the fifth is that after notice to the consumer or authorized representative as to the completeness of the repairs made, MDADR is to release the motor vehicle, which should be accompanied by an inventory of repairs done as completed and those parts of the vehicle which were replaced. Those parts replaced as well should be returned to the consumer by the MDADR and to furnish the consumer the results of any test activity which was performed to the motor vehicle. And the last step is the consumer to receive the repaired motor vehicle. Caveat or ang meaning is beware. Beware si consumer kasi the general rule, if the repaired vehicle is not returned within 15 days from release, tapos hindi na return yon, the repair done by MDADR is deemed accepted or completed. However, such general rule admits an exception. which is well provided for by law. In that, if the same non-conformity still exists or persists after the 15-day period to return, but is still within the lemon law rights period, the law provides that consumer may still be allowed to avail of the rights and protections under sections 5 and 6 thereof. Sorry, I think may background sound ng tahol, yung maaso. So let's now go to how to avail lemon law rights. So there are 5 steps in this case. So first, there should be compliance with at least 4 separate attempts by the same MDADR for the same complaint. So emphasize that 4 separate dapat siya na repair attempts by the same MDADR, tapos same dapat yung complaints niya. Addressing the same complaint. So the next one is the consumer is to provide a written notice to the MDADR of the unresolved complaint, stating therein his or her intention to invoke rights and protection afforded for him or her by the Philippine Lemon Law. Next is to bring the motor vehicle to the MDADR for a final repair attempt. So, ito yung compliance niya with the requirement under Section 7. And then, fourth, despite final repair attempt by the MDADR, such repair was proven futile or unsuccessful. Hence, only by such time can the consumer may file a complaint with the Department of Trade and Industry. So, next. Dispute resolution mechanisms by the DTI. So, hindi ko masyadong kukomplikahin ito. So, first is mediation to be filed before the DTI. However, the DTI in here will observe the principles of negotiation, conciliation, and mediation, and the main objective of this dispute resolution mechanism is that to reach an amicable settlement between the parties and to end such dispute by amicable settlement nga. So, ang period na to is that all disputes that has been submitted for mediation shall be settled not later than 10 working days from the date of filing of the complaint with the DTI. So, beyond 10 days, the parties may now execute a certificate attesting that they failed to reach an amicable settlement. And then next is arbitration. In case of mediation fails, the parties may then voluntarily agree that they decide to undertake arbitration proceedings. The prominent characteristic of this mechanism is that those persons who will compose the Board of Arbiters who will decide the dispute as a general rule shall be chosen and agreed upon by the parties, provided they are not expressly disqualified by law. However, if both parties have decided not to undertake arbitration proceedings, at least one of the parties may now commence an adjudication proceedings to be administered by a DTI adjudication officer who shall rely on a qualified independent finding as to conformity of the subject motor vehicle to the standards and specifications established. However, the adjudication proceedings shall in no case exceed 20 working days. So, yun. Pag may ruling naman si adjudication officer, it does not mean na doon na matatapos lahat. Hindi. Kasi within 15 days from such receipt of the parties of the final judgment or order of the adjudication officer, the aggrieved party or yung natalong party may now file an appeal to the DTI Secretary, who shall decide the same within 30 days from receipt thereof. However, itong appeal na to is limited on the following grounds. May grave abuse of discretion si adjudication officer in deciding the matter. The decision or order is in excess or jurisdiction or authority of the adjudication officer. Or last, the decision or order of the adjudication officer is not supported by the evidence or there is serious error in the findings of facts. So, hindi pa natatapos diyan ang remedies ng aggrieved party. After ng appeal kay DTI at hindi pa rin na-satisfy si aggrieved party as to the findings, the aggrieved party may now seek further appeal to the Court of Appeals through a petition for certiorari under Rule 65 of the Rules of Court, not later than 60 days from notice of the judgment, order, or resolution. So, take note, yung dispute resolution mechanisms na yan should be followed in accordance to such orders. So, hindi pwedeng tumalon ka kaagad to DTI Secretary to appeal to the CA. Kasi we have under the law, we have this concept of exhaustion of administrative remedies. So, bago ka mag-proceed sa court, kailangan lahat ng remedies available under the administrative bodies should be availed of first. Kung hindi, pag dumiretso ka sa court, i-dismiss yung kaso mo for premature filing. Next. So, ano nga ba yung lemon law rights na pinag-uusapan natin kanina pa? So, meron siyang tatlong klase. So, may lemon rights tayo during repair period. Siyempre, may-ari ka ng sasakyan tapos hindi mo nagagamit dahil nandun sa kasa, inaayos. So, kailangan may compensation ka doon for the deprivation sa right mo to enjoy your property. Hence, it is ordered or provided for by the law that the MDADR should provide to the consumer a reasonable daily transportation allowance. So, ang reasonable daily transportation allowance dito, ang tinutukoy nito ay yung cost of transportation from residence to regular workplace or destination and vice versa, equivalent to an air-conditioned taxi fare. So, air-conditioned yan. Taxi fare pa, di ba? As evidenced by an official receipt. Pero pwede rin itong masubject to an agreement between the parties. Or, pwede rin namang mag-provide si MDADR ng isang service vehicle na temporarily, yun yung gagamitin mo. Ito, ang option na ito is binibigay kay MDADR since siya yung magpo-provide ng remedies to the consumer. Next is yung lemon law rights naman natin after a ruling by the DTI adjudicator. So in case of a finding of non-conformity of the subject motor vehicle, so ang nanalo dito is yung consumer. So ano nga ba yung mga rights niya? So dito, ang right niya is to demand a replacement of motor vehicle from the MDADR with a similar or comparable motor vehicle in terms of specifications and values subject to availability. That's the first one. The next one is to compel the MDADR to accept or repurchase the subject non-conforming motor vehicle and pay the consumer the purchase price plus the collateral charges. And then next is yung last is to purchase a vehicle with a higher value or specifications from the same seller, in which case the difference between the purchase price plus the collateral charges and the purchase price of the new vehicle should be paid by the consumer. However, note in all those three cases, the reasonable allowance for use shall be deducted in determining the value of the non-conforming motor vehicle. So ano ba yung reasonable allowance for use? So Ito, pwede natin siyang i-relate to the concept of depreciation since nagamit naman kahit papano ni consumer yung motor vehicle, so kailangan mag-depreciate din siya. So reasonable allowance for use is 20% per annum deduction from the purchase price or the product of the distance traveled in kilometers and the purchase price divided by 100,000 kilometers, whichever is lower. So let's go to the next. So paano naman kung si MDADR yung nanalo sa ruling ni adjudicator officer? So ang may obligation naman sa part na to is si consumer to reimburse the cost in validating the consumer's complaint na nagastos ni MDADR. So next. So anong nangyayari doon sa mga ni-repurchase ni MDADR na non-conforming motor vehicle? So ang nangyayari diyan is usually ibabalik yan sa kasa and mag-undergo under several repairs. Tapos at saka siya i-resale. So ano yung mga requirements bago maging available for resale ang isang naibalik na motor vehicle sa kasa? So una is that kailangan i-disclose na yung motor vehicle na yon was subjected to repairs and that it was returned to the manufacturer, authorized dealer, or retailer. Next, the nature of the non-conformity which caused the return. And lastly, the condition of the motor vehicle at the time of the transfer to the manufacturer, distributor, authorized dealer, or retailer. So lahat ng yan is dapat ma-disclose ni MDADR or ni seller to the prospective buyer para hindi siya maging held liable. Kasi pag hindi niya na-disclose, ang kahit isa dyan is mape-penalize siya for at least 100,000 pesos as damages without prejudice to any civil or criminal liability under existing laws. However, may exception naman dito. Pag ang resale nung returned vehicle is dun sa first purchaser, hindi na kailangan i-disclose kasi in the first place, alam niya kung bakit niya binalik yung motor vehicle, di ba? Tapos, hindi rin kailangan ng disclosure if the sale was made by the first purchaser as the seller or any subsequent purchaser to the subsequent or yung mga susunod pang mga purchaser. So, yun. So, kumbaga, itong disclosure na to is direct lang from MDADR to the next prospective buyer ng returned motor vehicle. So, now, we'll go. So, yun yung end ng topic ko. So, we'll have 2 multiple questions for a quick review lang. So, I'll give you 15 seconds. So, which non-conformity is not covered for the reason that it is beyond the control of the MDADR? So, sana mag-chat kayo kung ano yung alam nyo na sagot. Para makita natin. So, ayun, may mga nag-chat naman kahit paano. Kinakabahan kasi ako, baka wala na nakikinig eh. Ayan. So, let's now see. So, oy, tama. Pwede na. Prepared na for sipale. Nice. Damage to the vehicle due to accident or force majeure. Kasi yung tatlo, yun yung sinasabi natin na attributable to the actions of the consumer. Kaya, hindi siya yung tinutukoy dito. Hindi siya yung tinatanong dito. So, next question. The following are not indicators of a brand new vehicle except. So, sagot ulit tayo. Sabi ni ma'am, may price daw yung mga overly active. Tignan natin, baka sakali. Sa next question, ano pong sagot natin? May sumasagot pa ba? So, okay na siguro yan. So, sa next question, ang sagot ay, yun, ay, galing. Kasi ano yung mga mali? Doon sa first choice, refurbished, dapat newly or new parts. Sa second, covered by a seller's express warranty. So, hindi si seller, kundi dapat yung warranty na yon is covered by the manufacturer. And dun sa last, hindi siya tama dahil operated na siya before in a foreign state. So dapat the vehicle must never been operated both on any highway of Philippines or any foreign state. So yun lang. Maraming salamat po, and kung may personal. Yan.